Good morning, everyone. My name is Beth Harrison. I'm a supervising attorney at Legal Aid. Thank you all for joining us today for our second session of this basic housing law training. And I am actually going to turn it over to Lori Leibowitz, who's on the line, who is a supervising attorney with the Neighborhood Legal Services Program, and she is going to start us off this morning. We will take 2 breaks during the training for like 5 or 10 minutes. And if folks have questions as we're going, what I would ask is that you put them in the chat box, and I will be trying to monitor that. It's difficult to do that when you're actually doing the slides. But we'll try to keep an eye on that and, either answer them in the chat box or say them out loud so that we can address them for everyone. Thanks, everyone.
Thank you. Good morning, everyone. I know that video stuff is hard to pay attention to, so I will try to be as interactive as humanly possible. So there are a bunch of housing subsidy programs. So we're going to talk about what the programs are and their categories and how to recognize them. Then we're going to talk about how they relate to eviction cases and subsidy termination, and then some little technical stuff on joinder. Next slide, please. Okay. So I like to divide subsidized housing into 2 main categories. There's a category of subsidized housing that I talk with my hands, and I want you to be able to see my hands on camera, but you can't. So category 1 is subsidies that are attached to the unit. So whoever lives in that unit gets the subsidy. And if you move out of the unit for any reason, you lose the subsidy. And then there's another category of subsidies that is held by the actual tenant, and wherever the tenant lives, they can take their subsidy and move with them. So the 2 largest categories of site-based subsidy are public housing, and that's housing that is owned by quasi-governmental, like the DC, in this case, DC Housing Authority. Then there is site-based Section 8 or project-based Section 8. You'll hear it called both things. And those are privately owned buildings that have subsidies attached to them. And the owners actually apply for and renew their subsidies. Then there is the Section 8 voucher program. You'll hear it called the Housing Choice. You'll hear it called Section 8. You'll hear it called HCVP, the Housing Choice Voucher Program. You'll hear it called vouchers. For all of these programs that I've talked about, a tenant's rent is roughly 30% of the tenant's income. There's a whole calculation sheet with various deductions and things, but roughly speaking, it's 30% of the tenant's income. So if someone thinks their rent is super off, you can multiply their income by 0.3 and see if it's in the ballpark at least. Folks have to recertify their income. It's every 2 years for public housing, could be 2 or 3 for HCVP depending, and for site-based Section 8, it's every year. Tenants must report changes in income and household composition. If someone moves in, if someone moves out, if they get a new job making more money, if they lose their job and are making less money, they have to report between regular recertifications. There are particular rules about things that you don't have to report, but my philosophy is if in doubt, report. And depending on the program, essentially whether it's a subsidy that is owned by the tenant or held by the tenant, then the tenant can move to different places. And if not, then transferring is much more difficult. Next slide, please. Okay, let's talk about public housing. So like I said, DCHA owns these properties and they typically manage them, although they sometimes have some of the properties have private management companies, which causes all kinds of challenges. And then just as another category, there are some Hope 6 and other kind of redeveloped public housing sites that have weird ownership structures. And there are some specific regulations for those. So HUD provides funding, federal funding to DCHA. In large, it's called an annual contracts contribution, ACC. But essentially the money comes from HUD to DCHA to run these properties. There is one standard lease. Every public housing tenant in DC should have the same lease. And tenants have the right to transfer between or among different public housing properties, but they don't have the right to transfer to a non-public housing property. There are some different things with this when redevelopment happens, and some people may be vouchered out or transferred unwillingly, but generally speaking, that's how transfer works. And I see on this slide, and I'm gonna actually go back to my last thing. No, actually there's another slide about this, never mind. So you recertify, so this recertification that I talked about a minute ago about people having to every couple of years bring all their information about who lives in the house and what their income is, that happens in the rental office at your building. And also interim recertification. So if you have a change, someone moves in, someone moves out, you have a baby, you lost your job, you got a new fabulous job, that all that information goes to the on-site rental office. Okay, next slide, please. From the tenant's perspective, in a similar way to public housing, the subsidy is tied to the property and the unit. It's owned. But the big difference is it's owned and operated by private landlords, and they contract with HUD. Each unit has a contract rent. The tenant pays their income-based rent, and HUD pays the rest of it to the landlord. So the landlord has to keep in touch with HUD. You know, this unit is worth $1,000 a month. My tenant is paying $200 a month. HUD, you pay me $800 a month. Oh wait, my tenant lost her job. Her rent's down to zero. HUD, now please give me the whole $1,000. There are local regulations for public housing. There are no local regulations for Section 8. It's actually a totally, or project-based Section 8. It's actually a totally federally run program. The best guidance for this is in this HUD handbook 4350.3. I always, for many years now, have found it every time by just Googling HUD handbook 4350.3, so much so that just auto completes when I write HUD handbook on my Google at this point. It's actually really clear and well written. There are boxes with examples. There are sections on how to recertify. There are sections on applying. Most questions you will want to answer are in this handbook, and you can use this handbook you can cite to this handbook in motions, you can cite to this handbook in all of your court stuff. And it is almost always very compelling to the judge. This slide says slightly portable. I guess it is slightly portable. It is very, 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 very difficult to transfer from one project-based Section 8 property to another. You can transfer within the same property. So maybe from a 1-bedroom to a 2-bedroom in the same property because your family got larger, or there's something wrong with the conditions in your unit and you're transferring to another unit. Sometimes, very rarely, usually either when the landlord has done something wrong or there is a domestic violence situation, you can transfer between properties of the same landlord. So if you are in a project-based property that's owned by a landlord who owns a bunch of them, that's easier. Sometimes a landlord really just owns 1 or 2 and there just isn't a transfer to be had. Recertification happens on site, again, with the property manager at the rental office, just like with public housing. A good tip to figuring out whether someone has a site-based subsidy or a voucher is whether they recertify on the property or at the DCHA headquarters. Next slide, please. All right. So I've referred to it a number of times, but what people often refer to as Section 8. So when people say Section 8, they're usually talking about this, but there are two kinds of Section 8. Totally confusing, but you guys got this. So the Section 8 voucher, the Housing Choice Voucher Program, HCVP, that's the tenant, those are, or we call them tenant-based vouchers, right? Project-based, tenant-based. These are the tenant-based vouchers. It means the tenant holds the subsidy. The tenant gets literally a piece of paper from the DC Housing Authority. And they use that piece of paper just like, you know, when you go to the store and you have like a $1 off your Cheerios coupon, right? Like they go and your store has to like send that coupon to General Mills to get the dollar for the Cheerios. It works a lot like that. You go and you, as a tenant, and you find the place you want to live. There are some rent caps. You can't be living in the, you know, luxury $4,000 a month for a one-bedroom apartment places. But the payment standards are pretty reasonable in my experience. Some people on the phone might disagree with me, but anyway. And those payment standards are available on the DCHA website. Again, I recommend Googling DCHA payment standard as the easiest way to find it, but I think it's dchousing.org/rent. And so tenant decides to rent, makes an agreement with a private landlord to rent, and then they go through a lease up process with the private landlord. As a side note, because it is an area of personal importance to me, landlords in DC are not allowed to say they don't accept vouchers. That is called source of income discrimination, and it is illegal. It is the same illegal as saying I don't rent to women or I don't rent to Black people. It is a violation of the law. You are not allowed to discriminate against vouchers holders in DC. No source of income discrimination in DC. Okay, back to our regularly scheduled program. So vouchers are administered through the DC Housing Authority. There are both federal and local regulations, and they are on this slide, which you will be getting a copy of, so I'm not going to read it to you. Yeah, so you can move, and usually you can only move after 12 months of living in a particular place. But if there's some kind of emergency, usually related to housing conditions, or some kind of violent situation or some other, or you can make a reasonable, then you can move faster than after the first year. Recertification happens at the DCHA office, which is 1133 North Capitol. The reason we put in here about the recertification stuff, your clients know that. You're not giving that advice to people. It's a way to figure out what kind of subsidy they have. The easiest way to figure out what kind of subsidy they have, and therefore what set of regulations you're going to look at for your case, are to first ask, who's your landlord? You know, who do you write your check to? What's the name on your money order every month? Is it DC Housing Authority or is it some other name? If it's some other name, not DC Housing Authority, then it's either project-based Section 8 or a housing choice voucher. And so then your next question is, where do you recertify? Where do you bring your information? Do you go to 1133 North Capitol, or do you do it on the property? If you do it on the property, then it's a site-based subsidy. And you're going to want to look at that HUD handbook. And if you're going to if your client is going to 1133 to recertify, then it's a housing choice voucher, probably. And you're going to look at these regulations that are on the slide right here. Oh, they did put source of income discrimination on this slide. Source of income discrimination is illegal. Remember this. Okay, next slide. So we talked about the main programs. Just to make things extra fun and exciting, DC and the federal government have a bunch of other programs, all with lots of acronyms, because we're in DC, everyone loves acronyms, right? Okay, so And actually a program that you will see commonly among clients is the local rent supplement program, sometimes referred to as LRSP. It's basically the same as HCVP, the Housing Choice Voucher Program. The local regulations are here, but essentially it's the same as HCVP. Actually, many clients don't know if they have an LRSP or an HCVP voucher. They actually get that piece of paper that I was talking about that you show to your new landlord. DCHA actually gives the Housing Choice Voucher Program piece of paper to people who have the local rent supplement program vouchers. So it is very difficult to know the difference, but the good news is the regulations are basically the same. So it's not that important unless your client is trying to move out of state, and you can take an HCVP voucher out of state under some circumstances, but you cannot take an LRSP voucher because it is local money. The Department of Behavioral Health has a voucher program. There is permanent supportive housing. There is Veterans Affairs supportive housing. Those of you who are following the slides note that I'm missing one in the middle. That's on purpose. I'm coming to it at the end. These are the Department of Behavioral Health, the VASH vouchers generally come with supportive services. There is also rapid rehousing, which has been in the press quite a bit over the past couple of years. You'll sometimes see it written as FRHSP, which stands for Family Rehousing Stabilization Program, but most people call it rapid rehousing. The regulations for it are listed here. It is limited to 1 year generally, and clients can get and request extensions, especially in this moment of pandemic. Extensions are actually being given quite liberally, but people have to ask. And they have to ask their case manager actually to ask DHS. So having a good relationship with one's case manager in rapid rehousing can be quite important. And you'll see cases where people are facing non-payment of rent eviction cases because they had rapid rehousing. The rapid rehousing ended and they can no longer afford to pay their rent. Although theoretically, rapid rehousing should be a bridge so that you can get back on your feet and pay your rent. But it generally does not sadly work that way. Last on the slide is low-income housing tax credit program. This has its own set of regulations. In part, they are actually IRS regulations because it's a tax credit program. And the important thing about low-income housing tax credit is that your rent does not change based on your income. It's done by income bands. So like below 30% of AMI, 30 to 50, 50 to 80. And so, and the unit is designated in that band. So if you were at 80% of area median income, and then your income dropped to 30% of area median income, your rent stays the same. So it's below market because it's based on what the average person in that income band can afford to pay, but it's not based on you particularly. So this is another one where if you lose your housing, you lose your subsidy, just like site-based Section 8 and public housing. And it's in some ways a greater risk to people because the rent doesn't change when their income changes. Okay. Next slide. I think I talked about this, but just in public housing, the DC Housing Authority is the landlord. Site-based Section 8, HCVP, all the other alphabet soup of programs, including low-income housing tax credit, there are private landlords. We talked about recertifying. Again, that's important. We see a lot of cases where people are getting evicted for failure to recertify. You can usually settle those cases by having your client recertify ASAP. They may actually have to pay some back rent if their income went up in the process. But that is grounds for eviction in many of these programs, or for subsidy termination. So recertifying is super, super, super duper important. Next slide, please. Okay, so we talked. An important thing to note is people in public housing also. So if you have a housing choice voucher, you have a housing specialist assigned to you at DCHA headquarters at 1133 North Capitol. For public housing and HCVP both, you're going to DCHA for things like reasonable accommodation requests, for things like moving requests, for if your property manager isn't doing what they're supposed to be doing, going over their head happens at DCHA. For site-based Section 8, and the wait list is administered for both of those programs by folks whose offices are at 1133 North Capitol. For site-based Section 8 or project-based Section 8, there is no relationship to DCHA. It goes HUD to the landlord, to the tenant. So any reasonable accommodation requests, any complaints, all go to the landlord, potentially the landlord's corporate office, or to HUD. So there is no, people who live in site-based Section 8 have no relationship at all, and their landlords have no, for that property, relationship at all with DCHA. Okay, next slide, please. All right. Eviction and subsidy termination, the sad things. For public housing, eviction is how a subsidy gets terminated. The subsidy is attached to the unit. If you get kicked out of the unit, then that's how you lose your subsidy. Eviction will result in the loss of a subsidy. So yeah. The other thing is you do have the right to a grievance hearing, but we have not found them useful as a legal services community. But there are some cases where it may be helpful to file a pre-court grievance because of you disagree with what the landlord is evicting you for, and they're in DCMR Chapter 63, that process is outlined. There is a really draconian one-strike law with regard to public housing. So any drug and I think we're getting to this later, but any people don't have an opportunity to cure for drug and gun-related crimes committed. Actually, anywhere. Fun fact. We have a case right now where someone's grandson committed a drug crime 20 miles away from the public housing complex, and they still brought a one-strike case against her, and they can. For site-based Section 8, a friendly reminder that feel free to put questions in the chat, and I would answer them. I will be happy to answer them. I can't see your faces, so I can't tell if there's any confusion. So you have to put it in the chat if you're confused. Site-based Section 8. So again, generally speaking, eviction terminates both the housing and the subsidy, but the landlord can also terminate the subsidy and charge you market rent and then sue you for non-payment later. Sometimes they do this if you don't recertify. There's no full grievance process available the same way there is for public housing, but the landlord must offer, if you request a meeting within 10 days of them sending you a notice to quit. Okay, so within 10 days of sending you a notice to quit, you can ask for a 10-day meeting, and sometimes we can resolve issues that way, and it mostly doesn't hurt the trick is you don't want to like give them free discovery and have people admit to things, but sometimes you can work out issues in 10-day meetings. And also my personal slogan of landlord tenant law is a delay is a win. So the 10-day meeting also gives you a chance, like forces them to push back the filing of a case, which is helpful in many situations. There was a question in the chat, which was, normally, how are landlords coming to know of the criminal action against tenants' household members? I believe, and perhaps if there's another housing attorney on the line, correct me, I think DCHA actually gets reports from MPD about it. Sometimes an arrest happens on the property and that's how they know about it. Often when the arrest happens on the property, they know about it. We've had a lot of cases filed against folks when a search warrant is executed on the property and it turns out like nothing was found, but they're like, they were police, they were in my hallway, you must have done something terrible.
Yeah, DCHA has a special relationship with MPD around this, and MPD does run addresses to see if incidents are happening at DCHA properties. DCHA also has a essentially special police force. They're MPD officers, but like work for I don't fully understand this relationship, but there are officers assigned to DCHA who also are considered MPD officers, but they work at the DCHA properties.
Okay, next slide, please. Okay, more sad things that happen to our clients. So for the Housing Choice Voucher Program, unlike the last two, the eviction and the subsidy termination are two entirely separate processes run by entirely different people in entirely different settings. So let's talk about eviction first, because that's easier. So if I have a housing choice voucher or a local rent supplement program voucher, and my landlord wants to get me out, they go to court and they engage in the procedure that we talked about last time and that we will talk about more pretty soon. Excuse me. And then you can take your voucher and you can live someplace else. I will say about this though, and this is a very important advice point for your client. It is a very, 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 very good idea if you're going to get evicted to move out before the marshals actually come and supervise a lock change, supervise the actual eviction, because if the eviction actually happens, then that is grounds for terminating the subsidy. So you want to try to settle, you want to try to move out. You ideally want to move out before there's a judgment, but if there's a judgment, you want to move out before the eviction actually happens. But there's a separate process that can happen after an eviction, right? DCHA could find out you got evicted for doing this really bad thing, and serious lease violations are a mandatory ground for terminating subsidy, and you can have a fight with DCHA about whether or not what you did was a serious lease violation. There are regulations on what serious lease violations are, but there's mostly just a catch-all. So it's something that we litigate on. But also DCHA can actually terminate the subsidy separate. Your landlord might think you're the best tenant in the history of the world, but DCHA can terminate your subsidy anyway. And then your landlord will probably have to evict you for failure to pay rent, but that will happen later. So the way termination of a tenant's subsidy works in the voucher program is DCHA issues a recommendation for termination, an RFT, because everything must have an acronym. So that often happens for failure to recertify, for criminal activity like we just discussed, for having unauthorized occupants. Sadly, there are rules against having extra people stay in your unit. tenant violations of housing quality standards. So landlords in all of these programs, I don't think we have a slide about this, so I'm just gonna go on a tangent for 1 second. For all of these programs, there are inspections for housing quality standards, essentially for how well how much the place is up to code. For site-based Section 8, and for public housing, HUD actually does those inspections, and for people with housing choice vouchers, DCHA actually sends inspectors to do inspections, and they're supposed to do it once a year. But they sometimes find that you, the tenant, like sometimes it's the landlord did the bad thing, but sometimes you, the tenant, are the one who is causing the housing quality standard problem. And so they will initiate a recommendation for termination. Tenant has 30 days to request an informal hearing. And if you do it within 30 days, DCHA will provide benefits pending. Essentially, they'll keep paying your landlord your portion while you're waiting to have your hearing. And this is particularly important because sometimes the Office of Fair Hearings at DCHA gets a little behind, and it takes time to actually have the hearing happen. It also sometimes takes time to provide. So you have the right to request your records when you're going to have one of these hearings, and you have the right to have those records before the hearing happens. And it often happens that folks don't have, DCHA has not provided the records by the time the day comes that the hearing was supposed to be, so you can get it continued. And so if your client is actually still getting their subsidy paid, it's not a problem that these delays are happening. If you miss the 30-day window, you can request a good cause hearing. The other thing is, while the hearing is happening, there is a lot of opportunity to help your client to cure, to submit their documents for recertification, to get their unauthorized document actually on the lease, depending on what it is, to fix whatever the housing quality standards thing that is wrong. So those are good things to be working on. And again, on this slide are the regulations around terminations, and there are things that DCHA is supposed to consider, mitigating factors, et cetera. So it is important to prep that. So if you have a hearing in front of an independent hearing officer, and who issues a written decision, if you don't like that decision, you can appeal the decision to the executive director. A fun thing that DCHA has started doing is sometimes appealing their good decision, the hearing officer's good decisions to the executive director. And if you do not like the decision that the executive director made, then you appeal to the DC Court of Appeals. And I think there is a question, so let me look at that. For an HCVP tenant, does eviction for non-payment of rent or judgment for landlord jeopardize the tenant voucher or just other lease violations? Yes, non-payment of rent is a serious lease violation. And in particular, actually, the Housing Authority looks askance at it because you should be recertifying, right? If you can't afford to pay your rent, you should be submitting documents to tell them about it. And so they feel like you don't actually have, like you have less of an excuse than other tenants to not be paying your rent. I don't agree with them, but that is what the law says. Next slide, please. Adam. Okay. So fun times, there are also consequences for the landlord, right? Remember I was talking about housing quality standards. If the landlord does not follow the rules for the voucher program, then the landlord's rent can be abated, and eventually, so they can say, we're not going to pay you rent for the next 30 days until you fix it. And then eventually, if the landlord fails inspection, usually 2 times, but they can ask for a third inspection, they will be terminated. So HCVP, the DC Housing Authority, stops paying. And then this is a situation where the tenant actually will not get in trouble for a non-payment suit. The tenant is likely to face an eviction suit for non-payment of rent because you know, from their perspective, they're owed $2,000 a month and the tenant's only paying $400, and DCHA was supposed to pay $1,600, but they're not paying it right now. So landlords are not supposed to. Okay, sorry. So when we have eviction cases and we ask for a jury trial, usually the landlord wants a protective order. They want the tenant essentially to pay their share of the rent into the court registry during the pendency of the case. And if the tenant cannot pay that money into the registry, then they can be sanctioned by losing their jury trial, having defenses stricken, etc. So one big thing that happens a lot is the landlord will ask for that whole $2,000 as the protective order amount. And we need to say, no, it's got to be only the tenant's portion of the rent. There is briefing about that. If you have a case, we can certainly provide you with the briefing that several of us have already done on the subject. And the sort of reference to Bell hearings here is you have the opportunity to ask for a hearing on the protective order amount. It's called a Bell hearing because of the case. And most commonly, those hearings are related to the conditions in the unit and that saying that it's not worth what the rent that we're paying, the tenant is paying because the conditions are so bad. But we also raise the tenant portion share when that comes up at Bell hearings. So if the landlord is as we're talking about, the landlord is the one terminated from the program, the unpaid subsidy is not supposed to be passed on to the tenant. There is a regulation about that. And it's actually in the contract that the landlord signs with the DC Housing Authority. The problem is that DCHA is terminating the contract. So landlords argue, well, you terminated the contract, so I'm not bound by the things I agreed to in the contract anymore. And so case law is a bit unsettled about whether the unpaid subsidy gets passed on to the tenant again. So if this comes up in your case, you'll want to brief it. And again, all the legal services providers have briefing on this issue that you'll want to ask us for. The other thing is landlords can't evict a tenant based on voucher status, but some landlords will purposely fail HQS and be terminated from the program in order to force a tenant out. That is source of income discrimination. And you may want to think about going on the offense against a landlord who does that. And then we'll talk about joinder later on in the slides, but if you think DCHA made a mistake terminating your tenant from their subsidy program, or made some other mistake in terminating the subsidy, you may need to involve DCHA in the landlord-tenant case. Next slide, please. Also, feel free to put questions in the chat. Next slide, please. Okay. Oh, joinder of other parties was the next slide. Great. If it is, yes. So it is not uncommon that we want to join DCHA to a case where the subsidy is at issue. If you think the subsidy provider should have paid rent or owes rent that your tenant is being sued for, you should file a motion to join. It is ideal to file it at the initial hearing. If for some reason you can't file it at the initial hearing, I would at the initial hearing say, we would like to join DCHA to this case. Please grant me additional time to file a motion to join DCHA. If there are specific rules of joinder in the LT rules, but the tenant has to serve DCHA and file proof of service. DCHA often opposes motions to join, so that's just something to be prepared for. Very often landlords' attorneys will consent. And the reason that it's important to file these motions for joinder is that a tenant can't be evicted for money owed by the joined party. But if you don't join the party, then your client could be evicted. So it's very important to make sure that if what your theory is that DCHA actually owes this money, not your client, you want to make sure you get DCHA into the case. It also often helps settle cases. DCHA will pay the landlord what is owed, and then the case goes away. Next slide, please. Okay, so there's a fun thing that you can do in landlord-tenant court, again, on the offensive, which is that you can ask for an abatement. You can say, my client has baby mice jumping out of her couch at her, and this bathroom ceiling is now living in the bathtub, so we cannot shower or bathe, and there's no ceiling in our bathroom. Or our house is full of mold, or all kinds of other terrible things that the landlord should be on top of fixing and isn't. And so I'm paying $2,000 for this apartment, and I can't really, and my stove doesn't work, and my fridge doesn't work, so I can't cook food. So it's not really worth $2,000. It's actually only worth $1,000. Just making the math easy here. And the court may say, you're right. And you shouldn't have been paying $2,000 a month for the past 12 months. You should have only been paying $1,000 a month for the past 12 months. So the landlord is suing you here for $2,000, but actually you overpaid your rent by $12,000, so the landlord owes you $10,000. Yay! But it gets a little complicated when the tenant is receiving a subsidy, because we don't want the landlords to get, sometimes our clients are only paying $100 a month, and we don't want to say to the landlord, well, the bathroom ceiling is inside the bathtub now. My client, the unit is only worth 50% of its value. My client's paying $100, so you lose $50 a month in rent, right? That's not a very good punishment for the landlord. So the 50% abatement is the whole rent. However, that could be an unfair, so we don't want to unfairly let the landlord get away with having a tiny abatement because the tenant's not paying that much. But it's potentially unfair for the tenant to get this huge windfall of money that they never actually paid in the first place. So you got to notify the subsidy provider so that they have the option. So the DCHA or whoever the subsidy provider is in this case could be, Department of Human Services, could be veterans, could be somebody else, Department of Behavioral Health. So they have the opportunity, the option to intervene in the case. If the subsidy provider chooses not to intervene, then the windfall does go to the tenant, and the tenant can receive the subsidy provider share of the abatement. If the subsidy provider does intervene, then they're entitled to a proportional amount of the abatement. So if the tenant is paying half the rent and the subsidy provider is paying half the rent, in my example, they each get $5,000. If the tenant litigates and obtains judgment for the subsidy provider may be liable for tenant's costs and attorney's fees. And that includes for legal services attorneys, even though we technically don't charge fees. Next slide, please. So this is just a little bit more about the process. The subsidy provider will file a motion to intervene. Your job as an attorney is to review that motion and confirm that the proportion of the rent that they're seeking is correct. They have an absolute right to their proportional share, so there's no, don't waste your time on an opposition. You're just going to want to make sure that they are telling you the correct amount. There unfortunately isn't a clear deadline on the timing of the notice. It's ultimately the court's responsibility. This could have an impact on a settlement. So, right, like you could, how much the rent is abated on the settlement. You could use it as leverage to say, well, I'm going to ask in court for money that's owed to the subsidy provider as well. But also theoretically speaking, if the landlord gives you an abatement in a settlement, it could be potentially the subsidy provider could ask to split it. So you want to just be careful about that. These are really good cases that explain this issue. If this is coming up for you in a case, I would come back to this slide and read these cases, which outline really clearly all of the things that I have just said. I am pretty sure that's my last slide, and the next slide says break on it, but let's find out. See, there you go. Subsidized housing can be confusing. Does anyone have any questions about what I just talked about? We promise we'll give you a break regardless. I was totally clear, not confusing at all. Okay. Well, maybe I was totally clear and not confusing at all. I have in fact trained on this several dozen times. If you have any questions, if you realize you have a question about this as we go on, I will be staying on. So feel free to put it in the chat and I can answer it at the end or jump in, or the other trainers probably can answer your questions as well. Are we taking a 5-minute break, Adam and Beth? I'm gonna say we're taking a 5-minute break. Okay. It is actually 11:57. Selena, who is a senior staff attorney from Rising for Justice, is going to talk about rent control and rent control housing. Selena. Don't actually know where Selena is, so perhaps I will start and then Selena can interrupt me and continue on. Okay. I can't see any of you. So we are going to talk about what properties are covered by rent control, what are the exemptions, what are the exclusions, what kind of rent increases can happen, what kind of petitions and things that landlords can do to get out of paying rent control, following rent control, other things about rent increases, and things that tenants can do when their landlords are doing things that are so sketchy that they're actually against the law. Next slide, please. Okay, so rent control started in 1975 when it was starting kind of across the country, and was changed 1980, 1985, and 2006, although what was passed in 1985 is pretty similar to what we have now. There were major changes in 2006, but they didn't really change the regulations to reflect those major changes. It's only been 14 years, no big deal. There is a draft currently out for notice and comment just in time for the regulations to hopefully change this year, because rent control has to be reauthorized by December 31st. So what we actually have in DC is rent stabilization, not rent control. New York City has rent control, with the government actually approving individual rent increases. Rent stabilization, which DC has, is rules that limit the timing and amount of increases. Some rent increases are automatic, while others are subject to prior government approval. And we're going to talk in more detail on the next slide. Next slide, please. Again, Selena, if you're here, feel free to take over. And if you have any questions, please type them in the chat. Okay, so we have a department in DC that is in charge of dealing with rent control or rent stabilization. It's the rent administrator at the Rental Accommodations Division. They keep copies of all rent control related papers. Those include exemption forms, rent increase forms, and housing provider and tenant petitions. So all landlords in DC have to submit a form to the Rental Accommodations Division saying whether their property is subject to rent control or exempt from rent control. This is true even of folks who, just rent out their basement. They are exempt from rent control, but they have to file a piece of paper that says so. The Office of Administrative Hearings adjudicates all petitions related to this. I actually just had a conversation with someone who was confused because the regs say you submit your documents to the Rental Accommodations Division. Essentially, you submit them to the Rental Accommodations Division, but OAH is the one that actually hears the cases. The Rental Housing Commission publishes the annual increases, amounts that people can use in rent control housing. They issue regulations on the Rental Housing Act, which covers a lot more than just rent control. And they hear appeals from housing provider and tenant petitions, which then go to the DC Court of Appeals. So essentially, petitions are heard in OAH, the Office of Administrative Hearings. They can be appealed to the Rental Housing Commission, and then you can appeal those Rental Housing Commission decisions to the DC Court of Appeals. Next slide, please. Okay. So generally, now I'm talking about landlords subject to rent control only. Subject to rent control only. None of these things, or most of these things, don't apply to most units that are not rent controlled. So the most common rent increase is the annual rent increase. So if your unit is rent controlled, then you can only have a rent increase once a year, and the rent increase amount is determined by, or is published by the Rental Housing Commission, and it is generally the Consumer Price Index plus 2% or plus 0% if you are elderly or disabled, but I think we'll get to that later. Housing providers can also increase the rent when a tenant vacates the unit. And if they want to have larger increases than the vacancy increase or the general annual increase, they have to file some kind of petition with the Rental Accommodations Division for specific things. And again, we'll get to that later. Housing provider and the 70% of the tenants can also make an agreement together to increase the rent on specific terms. These are called voluntary agreements. And again, we'll talk about those in more detail later. So like I was saying before, so officially the law says all units are covered unless exempt or excluded. There are a ton of units that are exempt or excluded, but landlords must actually file a paper saying that they are exempt or excluded. Next slide, please. Okay. So the code is here. So now I'm going to talk about units that are covered by the Rental Housing Act generally, but not subject to rent control. So all units that are district or federally owned, or the mortgage or rent is district or federally subsidized. So for those paying attention, that means if I use my housing choice voucher to rent your apartment, my rent is subsidized by the federal government. So quick, somebody put in the chat, if I have a housing choice voucher, is my unit subject to rent control, yes or no? Come on. Trying to make it interactive. Excellent. That is correct. No. If you have a housing choice voucher, your rent is not subject to rent control, although all of the units in the rest of the building that don't have vouchers may be subject to rent control. Fun facts for the day. And sort of all of the housing that we talked about at the beginning, none of those are subject to rent control. Any unit built after 1975, you can actually check on the year that a unit is built on the PIVS, DCRA PIVS, P-I-V-S website. If you put in an address, there are other places too, but that's I think the easiest to figure out where they are, what the year they were built. If you have a unit in a housing accommodation with 4 or fewer units owned by 4 or fewer natural persons. So if you live in a 4-unit building or a 3-unit building or a 2-unit building, then you are exempt from rent control. However, if that is owned by some kind of LLC, then it's subject to rent control. LLCs are not natural persons. If a unit was continuously vacant since 1985 and previously exempt under the 1980 law. I'm just going to say I don't know how we check that, but landlords can put that in that exemption form that I'm talking about. Landlords can check that off on the exemption form, and you can get a copy of landlords exemption forms from the rent administrator. If the rental unit is covered by a building improvement plan or has received rehabilitation assistance from DHCD, it is then exempt. Just to be clear, this covers a ton. There are a ton of units that are exempt from rent control. And just a note that it says units here, not buildings. Like I was saying with the vouchers, it can be the case that a particular unit is exempt, but the rest of the building is covered. So that's just a thing to be aware of. Next slide, please. And Selena, are you here? Selena, if you are here, then you can.
Hey, I'm here. Sorry.
Great.
How are you doing, Lori?
I'm doing great. You ready?
Yes.
Cool.
Okay. Hi, everyone. Sorry, I'm a little bit late. So I'm Selena Aldape. I'm from Rising for Justice. Thank you, Lori, for getting us started. So I know that you guys have been talking about subsidized housing, and Lori has given you a little bit of an introduction as to how the rent stabilization law works. One thing I like to emphasize is that whether a unit, as Lori was saying, whether a unit is rent stabilized, whether the rent level for a rent stabilized unit is the proper rent, is the proper level, things like that. All of those are somebody's position. All of those are something that either the landlord or the tenant is claiming is true. There's no universal truth about whether something is covered under rent control, what the proper rent level is. This is all something that can be litigated, and it's all something that it's going to be your role as advocates to figure out what your position is and figure out what you can do to assist a tenant who may be living in a rent stabilized unit, or a unit that should be rent stabilized but is not being treated as such, or who's being charged an illegal rent level. So we've just been over, I believe, some of the, let me just get to the slide in my PowerPoint, some of the exemptions from rent control. There's also some types of housing that are completely excluded from the Rental Housing Act. And these are probably not going to be things that you're going to encounter a lot. They're things like diplomatic housing, hospitals, school dorms, things like that. One of the ones that you might actually encounter is this bolded bullet point, long-term transitional housing for low-income tenants. This will often be characterized by a type of housing where the tenants have programming that they're, required or invited to be a part of as part of their housing. You may also encounter tenants who live in rental units that are covered by a building improvement plan or have other types of specific DC agency funding. If you encounter a tenant who you think might be rent stabilized, but you're not sure whether or not it falls under one of these exclusions, I would encourage you to reach out to one of your mentors, do a little bit more research, and we'll talk a little bit about how to get the documents that have information about whether a unit is rent stabilized. But just know that these exclusions exist and that you should be aware that they may impact whether or not a landlord can raise the rent in that. And here, let me put my video on as well. Okay, you can move on to the next slide. So as Lori mentioned, just because a unit is rent stabilized in DC doesn't actually mean that the landlord can't raise the rent at all. It's not like New York. It's not a system where every rent increase is, has to be approved. It's a system where the amount by which a landlord can raise the rent is limited in frequency and an amount, but there are some rent increases that landlords can take automatically. So the first one, the one that's going to be sort of across the board, you're going to encounter in pretty much any tenant who lives in a rent stabilized unit, is the regular annual rent increase. A landlord can take this general adjustment once per year, and the amount that they can take it is uniform. The percentage by which the rent can be increased is uniform throughout the city. So how does a landlord know how much they can increase the rent in a rent stabilized unit? That is determined by the DC government, and it's based on the amount of inflation in wages. So the formula is the CPIW, which is the Consumer Price Index for wages, plus 2%. So I know here it says for 2018, the CPI was 1.4%. So in the chat, how much would, in a general rent stabilized unit, how much would a landlord be able to increase how big of a rent increase would the landlord be able to take in 2018? It's simple math. Yes, so we have 3.4%. So every year, for example, I think in 2020, from May 1st through May 1st of next year of 2021, the landlord is going to be, the CPIW is 1%. So generally speaking, for a landlord who wants to take a rent increase during this year, the landlord is going to be able to take an increase of 3%. There's an exception, and that exception is for tenants who have registered as elderly or tenants who have registered as having disabilities. So an elderly tenant is defined as a tenant who's 62 years or older. A tenant with disabilities is defined as a tenant who has a disability under the ADA. If the tenant has previously registered as belonging to either one of these categories, then the landlord is only able to increase the rent by whichever is lower of the CPIW no plus 2%, or the Social Security cost of living adjustment. So in 2020, because the CPIW was lower, if you have a tenant who has registered as elderly or disabled, then the landlord is only going to be able to increase the rent in their unit by 1%. And I do want to emphasize that this is something that doesn't happen automatically. The tenant actually has to tell the rental accommodations division that they're elderly or disabled in order to be entitled to this protection. So if you have a tenant who qualifies for either of these characteristics, one of the things you're going to want to do is check to see whether or not they've submitted this document. And if they haven't, go ahead and do it so they'll get that protection. So how does a landlord implement this rent increase? So one of the big differences between units that are rent stabilized and units that don't qualify for any affordable housing program is that if you're in a rent stabilized unit, the landlord is going to have to provide documentation of every single rent increase to the rental accommodations division. And this is where a lot of our power as tenant advocates comes from, because we can look at whether the landlord actually did provide the notice that they were supposed to. This notice allows us to keep track of all of the rent increases that happened over the previous couple years to see whether or not the landlord was acting in compliance with the rent stabilization law. So it's really important, number one, that there is this requirement that the landlord has to file with RAD the actual, a sample notice of the type that they sent to all the tenants within 30 days of them being eligible for it. It doesn't go under any kind of independent oversight or review. I want to emphasize that too. RAD is not looking to see whether or not the landlord actually did increase the rent at a time that they were allowed to or anything like that, unless there's a glaring facial defect with it. And maybe not even then. What you're looking at when you look at the landlord's notice that they file with RAD is a notice that says what the landlord is asserting that they have the right to do. And it's our job as advocates to look at those notices of rent increase and determine whether or not they're actually, only being taken once a year, and whether or not they are complying with all the other requirements of the law. Next slide. Okay. So that was the general rent increase that any landlord who owns a rent stabilized unit is able to take once per year. There's some other special circumstances under which a landlord is going to be able to take a rent increase. Some of them are only under special circumstances but don't need prior government approval. Some of them are only under special circumstances but do need government approval. So first, the first category, which is other special circumstances under which the landlord can take a rent increase that's higher or more frequent than they would normally be able to do. And that's called the vacancy increase. So that means that every single time that a tenant leaves a unit, it leaves it vacant, the unit turns over, the landlord can take an additional rent increase of the type that they wouldn't have been able to take otherwise. The law on vacancy increases has changed a little bit. I want to talk about both because they're both something that you might encounter. So before the new law that took effect in 2019, a landlord could take a vacancy increase whenever a tenant left the unit, either of 10%, or if they could point to another unit in the building that they could claim was substantially comparable or substantially identical to the unit that became vacant, they could take a higher increase of up to 30%. They can't do that anymore. Now it's just pegged to how long the tenant lived in the unit, the previous tenant lived in the unit. So if it was 10 years or less, the landlord is entitled to a 10% vacancy increase. If it was longer than 10 years, then the landlord can take a 20% vacancy increase. But you might see both, because as we'll talk about in a little bit, if you have a tenant who wants to challenge what their rent level is, you might be looking up to 3 years back in terms of rent increases. And so you may actually have a tenant who as challenging a vacancy increase under the old law. If you encounter this, I encourage you to reach out to your mentor because it is really going to be really important to figure out which law the landlord was proceeding under. So similarly to the general notice of rent increase, this is also something that the landlord has to file with the rental accommodations division in order to perfect it, in order to implement it. The landlord is going to have to provide to the new tenant a disclosure of how much the vacancy increase was and previous rent increases as well. And this again is something that the DC government is not going to be independently looking at. It's something that it's going to be our job as advocates to see if there is a challenge to them. So we have a question in the chat. Does vacancy equal termination of the lease or an actual empty apartment with 0 tenants? So for example, a situation in which one roommate wants to move out and the other wants to stay. So that's a great question. That's actually one that I think comes up a lot, and maybe Beth or Lori has a better answer to this. I think that the argument is that if the tenant who stayed is still there, that there wasn't a real vacancy, that the tenant is still living there and that the landlord shouldn't be able to bring a new rent increase. But I have definitely seen landlords claim that because the previous lease ended and now there's a new tenant moving in or something like that, that should count as a vacancy. I actually don't know whether or not there's any law clearly on our side about this, but I would definitely, as advocates, I would absolutely argue, no, they should not be able to take a vacancy increase in that situation because there was no actual vacancy. There's still someone who's continuing to live there who was living there prior to the other roommate moving out.
That is exactly the same answer that I would give, Selena.
Great. Thank you, Laurie. Okay, next slide. Okay, so we've talked a little bit about the automatic rent increases that landlords are going to be able to bring. Those are the general increases and those are the vacancy increases. Those are the ones that you're going to be most commonly dealing with. And they're going to be the ones, if you're representing an individual tenant, they are probably going to be the ones that you are most concerned with in terms of making sure that that tenant has a legal rent level, and if they have any challenges to it, bringing that challenge. But you should know about a variety of other ways that the landlord can increase the rent by submitting petitions or agreements to the rental accommodations division and trying to get those approved. There's a couple different kinds of those. I want to go over them relatively quickly. The first is a hardship petition. So in DC, a landlord is actually entitled to a 12% annual return of investment on their property. I know many tenant advocates think this is too high. It is something that is people are advocating for that to change, but right now a landlord is entitled to a 12% return of investment on their property. And if they can demonstrate to the rental accommodations division that they're not making that return on investment, then they can ask for what's called, they could file what's called a hardship petition to increase the rents across the board in a building so that the landlord can meet that rate of return that they're entitled to. So in order to implement a hardship petition, the landlord is going to have to actually file it with RAD. They have to provide information about the equity in their building and other buildings, things like that. There's a government audit performed, and the tenants actually then have a right to challenge that hardship petition within 30 days. If they do so, then the petition is transferred over to the Office of Administrative Hearings to essentially have to litigate about it. A couple important things to note are that number one, if the landlord can show that they actually have negative net income and RAD doesn't issue any kind of ruling within 90 days, the landlord has the right to take what's called a conditional rent increase, which is a 5% increase for the duration of the pending period between the 90 days and the day that RAD actually makes the decision. It's also important to note, just like the elderly or disabled exemptions in the general rent increase notice, there's also an elderly or disabled exemption in hardship petitions if their income is below a certain amount, and that's 60% of the average median income. Next slide. The next kind of petition that a landlord could follow is called a capital improvement petition. This is one of two kinds of petitions that a landlord can try to get approval for if they're trying to improve the building, if they're claiming that they're trying to make the building better. So a capital improvement petition covers the cost of capital improvements either to some units in the building or the entire building. The landlord has to meet certain standards, such as showing that it protects or enhances the safety of tenants or the habitability of the building, or it makes the building more environmentally friendly. There are some specific ways that the rent increase that can then be applied to the tenants is calculated. I would refer you to the slide. I don't want to get too much bogged into the details here. But similarly to the hardship petition, this type of petition is filed with the Rental Accommodations Division. If the tenants want to challenge it, it's litigated before the Office of Administrative Hearings. And again, there's elderly or disabled exemptions for the capital improvement petition. And if you'll move to the next slide. Somewhat similar is a substantial rehabilitation petition. This is also a petition that the landlord can file to try and increase the rents across the entire building. So if the landlord is saying that the cost of the rehabilitation exceeds 50% of the value of the property, and it's in the interest of the tenants, like the landlord can demonstrate in some way that it will improve the health and safety or condition of the property or anything like that, then this kind of petition might be improved. Similarly to the capital improvement petition, a substantial rehabilitation petition has certain calculations as to how much the rent increase can be depending on the cost of the rehabilitation. Unlike the capital improvement petition is a surcharge for a specific period of time. The substantial rehabilitation petition is not a surcharge, it's just a rent increase. Similarly to the other types of petition, this is filed with RAD, adjudicated at OAH if the tenants have a challenge to it. And there are some additional specific provisions for if the tenants have to be relocated. During the substantial rehabilitation, there's some specific ways that the landlord, some specific notice and help that the landlord has to give the tenants in those situations. Next slide. And then we have services and facilities petitions. So right now we're focusing on ways that the landlord can ask RAD for permission to change the rent in some way. A services and facilities argument is one that both the landlord and the tenant have the right to bring. I'm going to talk about the tenant right to bring a services and facilities argument a little bit later. So right now we're just focusing on what the landlord can do. So essentially, if the landlord wants to increase the rent in a rent stabilized unit because the services or facilities that they're providing have changed, then they can file a petition asking to do so. So it might be common to do this, for example, if the tenant was previously paying for a utility, but it switches over to the landlord paying for a utility, the landlord may want to increase the rent in order to keep, because the services that they're providing have increased. The administrative law judge will consider things like the cost to the tenant of getting a comparable service or facility, or the cost to the landlord and the market value. Again, this is filed with RAD, adjudicated at OAH, and there are some exemptions for elderly tenants who are elderly or have disabilities. Next slide. And then the final type of sort of big overall building-wide rent increase that I want to talk about, which is something that you might see, is a voluntary agreement. So a voluntary agreement is not a petition. It's an agreement between the landlord and 70% of the tenants in the building, in which they both mutually agree that the landlord is going to raise the rent in all of the units in the building in exchange for providing something in exchange, like increasing the services and facilities in the building, or providing rehabilitation services or something like that. So it's important to note, number one, that 70% of the tenants in the building have to sign on in order for a voluntary agreement to be approved. But once 70% of the tenants sign on, the other 30% of tenants are still going to be affected. So it will implement a rent increase throughout the entire building and affect the tenants in the entire building, even if 30% of them don't necessarily agree to the terms of the voluntary agreement. So once a landlord and a tenant have worked out a voluntary agreement, they will propose this agreement to the Rental Accommodations Division. Tenants then have some time to review this. And then the Rental Accommodations Division is actually required to approve it unless they find that there's duress or harassment or intimidation, or if there's other kinds of fraud, if it contradicts the purposes of the act, which are generally to keep housing affordable, or if it treats tenants unequally. So if the rent administrator disapproves of the petition or a tenant objects, then it goes to the Office of Administrative Hearings for litigation. And again, there are elderly or disabled tenants exemptions if the tenants meet certain income guidelines. This is something that you see a lot of the time when a landlord is trying to buy tenants out. So oftentimes a voluntary agreement will happen sort of in conjunction with the landlord giving tenants some cash in order to move to a different apartment in exchange for being able to take large rent increases in the now vacant units and rent them to tenants who are then going to be paying more. So it may be something that comes up or that you see happens, and there should be records of this at the Rental Accommodations Division, although you might not be able to see them in the same way that you're able to see all of the other notice of rent increases and things like that that a landlord has to file. So if you encounter like a tenant who has a really big increase in rent that happened in the last couple of years, you may be dealing with either a voluntary agreement or some kind of petition, and that should flag you to try and either speak to your mentor or speak to the folks at RAD and try to figure out what was going on and see if you can get the documentation regarding that. Does anybody have any questions about, I know we've just been over a lot of detail about landlord petitions. Before I move on to how is the 70% determined? So this is a comment in the chat. How is the 70% determined? What if some units are larger or have more occupants than others? And does the calculation ever make a practical difference? So that's a good question. I actually don't think, maybe Lori or Beth could jump in on this. I think that it's just 70% of the tenants and doesn't necessarily include other occupants who are.
It's by unit, so each unit gets to have a representative to vote.
Thank you, Lori. So 70% of the units are in agreement, then the other 30% of the units can be affected. Any other questions? Okay, I'm happy to answer questions at the end too, but for now we can move on to the next slide. So when you meet a tenant and you suspect, okay, so sorry, we have another question in the chat. How do vacant units factor into the 70%? So again, Lori, if you have a different answer, but my understanding is that vacant units are not part of the calculation either way.
That is my understanding as well. Yes.
So it's,
they don't like, so if you have 20 units in the building and 2 of them are vacant, then it's as if you have 18 units in the building.
Right. So if you meet a tenant and you are trying to figure out you suspect that they might be in a rent stabilized unit, or you suspect that they should be in a rent stabilized unit, but their landlord is not acting that way, one of the things that you're going to want to do is sort of look back at the history of the times that the landlord has increased the rent and see whether or not you think those rent increases were proper, what provision those rent increases were taken under, whether they were a general adjustment, whether they were a vacancy increase, whether they were due to some kind of petition or voluntary agreement. And there's a couple different things that you should analyze in order to try and figure out whether or not those rent increases were proper. So, number one, in any kind of situation, the landlord can only raise the rent in a rent stabilized unit if the unit is in substantial compliance with the housing code. The landlord is actually required whenever they submit like a registration with RAD or anything like that to certify that the unit and the common areas are in substantial compliance with the housing regulations. So this means that, for example, if my landlord tried to raise, if I'm in a rent stabilized unit, my landlord tried to raise the rent on me last year, but at the time I had like a leak in my ceiling that the landlord was responsible for, but the landlord didn't fix. Even if everything else that the landlord did was correct, even if they gave me proper notice, even if, you know, the amount of the rent increase would have otherwise been okay, I actually, as a tenant, have the right to go back and challenge that rent increase because at the time, the landlord, by raising the rent, was certifying that they were in substantial compliance with the housing code. And if they weren't, they knowingly were not, then I have an argument that that rent increase should be rolled back. And we'll talk a little bit in a second about the types of petitions and other challenges that tenants can bring in order to do this. But one important question to ask your client is, when the landlord increased your rent, were there any problems in your unit? Were you having maintenance issues? Was the landlord refusing to fix anything? The next requirement is that the landlord can only raise the rent if they are properly registered and licensed. So first of all, each rental unit has to have like a basic license in order to be able to use it as rental housing. Secondly, if the unit is supposed to be rent stabilized because it's not subject to any of the exemptions or not subject to any of the exclusions, as Lori mentioned, the landlord is also going to have to file something with the Rental Accommodations Division saying, here is my registration. I am either exempt from rent stabilization for these reasons, or I am not exempt from rent stabilization for any of these reasons, and therefore I'm subject to rent stabilization. So if they haven't, if they were supposed to file one of these registrations or claims of exemptions and they didn't do it, then the administrative law judge can also roll back a rent increase for that reason, because they weren't registered when they took the rent increase. Similarly, the property manager also has to be registered. And finally, and this is an important one that I see violated a lot, the landlord needs to give 30-day written notice of the rent increase. So first of all, I just want to make clear, if the tenant is within the period of their written lease, like if they've signed a 1-year lease that says your rent is $1,000, the landlord, while that lease is in effect, cannot just, even if they would otherwise be able to take a rent increase under the general adjustment of applicability, they wouldn't be able to increase the tenant's rent just because they would otherwise be able to, because they're within a lease term. So here we're really talking about tenants whose leases have expired. As you guys know, the tenant can continue living in the unit month to month as long as they keep paying their rent. But if you see a landlord who gives the tenant a rent increase notice, but the tenant is still within their lease, that independently is its own problem. If there's no current lease term, then the landlord can, under the rent stabilization provisions, give a tenant a notice of rent increase, but it has to be at least 30 days in advance. And that's 30 days before the first of the month that the next rent is due. So for example, if my landlord were to give me a rent increase notice today, June 11th, 30 days from now would be around July 11th, and then the landlord would have to wait until the first of the month or whatever day rent is due, like August 1st, in order for that rent increase to be effective. So if a landlord demands a rent demands rent, that I pay the rent increase on July 1st, when they just served me with the notice today, that would be another argument that the rent increase would be unlawful. There are also important provisions where the landlord is required to provide notice to the tenant. So any current tenant in a rent stabilized unit can ask for a list of the rent adjustments for the past 3 years. So remember, I was saying that one of the important parts of the rent stabilization law is that all of these things are documented, they're filed with RAD. All tenants have access to RAD. I'm not sure right now exactly what they're doing with COVID-19, but in general, all tenants can, you or your staff or tenants, any of those can go to RAD and actually look up the history of everything that the landlord and tenant have filed in terms of these general rent increase notices. Unfortunately, a lot of the time, these documents are not actually on file because RAD has some difficulty scanning and inputting them all electronically. But that is one way in which you can get these documents, but the tenant also has the right to ask the landlord for all of those rent adjustments within the last 3 years, so that you and your client can sit down together and really track the history of these rent increases and figure out whether or not there's any opportunity to argue that some of them were not legal. Additionally, we had been talking a little bit about like vacancies and landlords being able to take vacancy increases. If a unit becomes vacant, a rent stabilized unit becomes vacant, and somebody else is going to move in, a prospective tenant, the landlord has to give that prospective tenant notice of the current rent, notice of whether or not the unit is subject to rent control or exempt from rent control, notice of any petitions and any current rent surcharges, and additional information about the housing code violations and ownership of the property and everything like that. So if a tenant moved into a unit and the landlord didn't give them any of these proper disclosures of rent increases over the last 3 years and everything like that, then the tenant might actually, again, be able to challenge some rent increases that happened even before the tenant was living in the unit. Next slide. Okay. So we've talked a lot about potential arguments that a tenant could have. Now I want to talk about how actually does a tenant bring those arguments? Like, how do you get in front of somebody who's going to be able to litigate whether or not what the landlord is doing is in compliance with the rent stabilization law or not? One of the major vehicles for this is a tenant petition. Any tenant in DC who is living in a rent stabilized unit or who is claiming that they should be living in a rent, like that their unit should be rent stabilized, can file a tenant petition claiming that either number one, the rent increase was not valid under the rent stabilization law. So this means that either the landlord took the rent increase at a time that they weren't supposed to be able to do so, that they didn't give proper notice of the rent increase, that the landlord is claiming the unit is exempt when the tenant is arguing it's really not exempt, that the landlord raised the rent by too much or too frequently. Any of those sorts of arguments that have to do with like the landlord violating all of these requirements that we've just talked about, all of those the tenant is going to have the ability to file a tenant petition in order to challenge. Additionally, in that same tenant petition process, a tenant can argue that services and facilities have been reduced or eliminated. So like I just talked about, if a landlord says that they've increased the services, if the tenant is saying, look, when you charged me this rent, you were including X, Y, and Z services and facilities, and now you're no longer including them, the tenant can ask that the rent be lowered proportionally due to the amount by which the landlord has reduced services. One of the most common ways that we see this as tenant advocates is if the landlord has really ceased to do maintenance and repairs as they're required to do under the DC Housing Code, and as a result, the unit isn't up to code. For that reason, the tenant can argue, well, the landlord is supposed to provide the service of regular maintenance. They're not providing this service of regular maintenance, and therefore I know you guys have probably talked a little bit about defending eviction cases in terms of like raising housing code violations as a defense. A similar vehicle is available in a tenant petition. So any tenant in any rent stabilized unit who has either of these arguments can file a tenant petition arguing either of those things. The tenant petition is going to be filed at the rental accommodations division, but pretty much as soon as it's filed, it gets sent over to the Office of Administrative Hearings, where you get assigned an administrative law judge. You have a mediation with a different judge, and then eventually you have an evidentiary hearing where the administrative law judge hears all the evidence and makes a determination. All tenants, regardless of whether they're rent stabilized or not, also have the ability to file a tenant petition for certain things. These come up less often, but it's important to know about them. Number one, if a landlord has served a notice to quit on a tenant, telling them that they have to vacate within 30 days or 90 days or whatever provision of law they're progressing under, the tenant does technically have a right to file a tenant petition stating that that notice to quit was insufficient in some way and that the landlord shouldn't, and arguing that the landlord shouldn't be able to act on it. In general, many tenants choose not to do this. In some ways, it brings to the landlord's attention an argument that their notice to vacate is wrong in a way that you could bring up, later. Oops, sorry. So I only have 15 minutes. So you should just also know that tenants could also bring up, any tenant can also bring up arguments for retaliation or security deposit violations or unlawful interference with a tenant organization. If you have questions about any of these, please reach out to your mentors. And then we can move on to the last slide. So the types of relief that the tenant is going to be looking for when they file a tenant petition can come in a couple different forms. So number one, you can get the rent increase negated, essentially. It will be as if that rent increase never happened. Second, if the landlord is acting willfully or maliciously, they could actually have fines imposed on them by the DC government. Finally, the tenant can get attorney's fees if they win and they file a motion asking for attorney's fees, which can actually be extremely important leverage in terms of negotiating a case. If you think you're going to win or you know that you're going to get something in favor of the tenant, that can give you a lot of bargaining power in terms of coming to a negotiation with the landlord. Next, the administrative law judge can actually give the tenant a refund of any rent that the landlord illegally demanded, and that happens whether or not the tenant actually paid it. So if last year my landlord raised my rent from $1,000 to $1,200, and I haven't paid it because I've been maintaining it's wrong this entire year, I've just been paying the $1,000 without the $200 increase, then at the end, if I win at the end of the case, the administrative law judge can actually order that I receive damages for $200 a month for every month that the landlord was charging me that, even though I didn't pay it. So again, this can be really powerful, and you could actually be entitled to treble damages if you prove that the landlord was doing it in bad faith. And if you get to the point, hopefully you will, where you are able to get a money judgment through OAH in favor of your client, then to collect on that judgment, you could enroll it as a judgment actually with the DC Superior Court. There are also other things that you could work out with the landlord, such as using it as a rent credit or using it as part of defense in a landlord-tenant branch. Thank you for noticing, for listening, I'm sorry. If anybody has any questions, please feel free to ask them in the chat as we move into the next topic, and I will stay on chat and try to answer some questions.
Are running super behind, so I think we're gonna skip the break. Apologies. Melanie, are you ready?
Yes, I am. Hi, everyone. Thank you so much for being here. My name is Melanie Acuna, and I'm a staff attorney with Legal Counsel for the Elderly. I know we're running late. I will try to go through this, but it is really important what we're covering today. We're going to talk about why you're doing what you're doing and who are you representing. When we need to look at our client population, a lot of our clients are coming from very little to no income, especially now with the pandemic. Many of our clients have lost their jobs or lost an additional income in their home. A lot of our clients are at or below the federal poverty level, which is about $12,700. And then some are just living off of just Social Security, and they're trying to get by in DC with that low income. Many of our clients have little to no experience with lawyers. They are getting documents from court and it's overwhelming, it's confusing. They don't understand, what is a summons, what do I have to do? So take that into consideration when you're working with these clients. It requires a lot of patience. Take into consideration any health conditions that they may have, any past traumas. Health conditions can range from mental health to physical disabilities. Past trauma is important to understand what our clients may have been through in the past, because we need to build trust with them. It is very important. And like all of us, they have competing demands. Some have children or daycare or work, and they're just trying to get by and juggle things one at a time. The numbers on the slide is really important to know that 1 in 6 residents live in poverty. 1 in 4 children are living in poverty. And east of the river, which are wards 7 and 8, where a lot of our clients come from, 1 in 3 residents are living in poverty. So really take into consideration how important it is for them to save their home. Thankfully, a lot of the referrals do come from subsidized housing, so their rent is based on income. But if they lose that subsidy, they lose their home. So it is very important. Next page. The work that we do is racial justice work, and it cannot be more prevalent than what we've been seeing going on and how important this is. Many of us know that there has always been racial inequities in the policies that are being made, but now it's really coming to light. So, thank you for volunteering to do this work and why it is so important. A lot of our clients, or a lot of people that go to landlord-tenant court, don't have attorneys, and they are forced into repayment plans that are unfair. But with your help, the clients will have a chance to get fair payment plans, to get housing code violations repaired, help with getting rental assistance, or even if it's time to relocate. And that's because they have an attorney on their side. The vast majority of our clients are people of color. If you've never been to the landlord-tenant courtrooms, you walk in and most of the defendants are people of color, while the attorneys are white. And we need to consider that the work we're doing is anti-poverty. We are helping the people of color to get equal justice, to save their homes. Next PowerPoint. Next page, sorry. Number one thing I would say when talking with clients is take a client-centered approach, empower them, build trust. That is number one, and create a relationship with them. How do you build the trust? How do you create a relationship? Well, you listen to them. You listen to their details, to their disabilities, to their family situations, their employment history. Make this personal for them. If you find that you can share something about yourself that is relevant, then do that. You let them know that you are just as a person as they are, and you may not have been through what they have been through, but try to stand in their shoes. I think one thing that's helped me, and I deal with a lot of elderly clients, is I like to talk about my mom. And when I do that, a lot of clients I've seen warm up to me. I've had one client that when she called, she goes, "Is this the lady that talks about her mom? That's the only person I want to talk to." And that means a lot, because I have built that trust with her, that she's able to talk to me about things that are now could be difficult if otherwise we didn't have that relationship. Some of these cases have personal information. You're going to have to talk about their financial situation, their health, or sometimes the violations that are being alleged could be embarrassing, or housing code violations that can be embarrassing, such as rodents or bed bugs. So in order for the client to have an open conversation with you, there needs to be trust. Also important for building a relationship is follow up with your clients. If you're going to say you'll call them, call them. Keep them updated to what's going on with the case. If not much is going on at the moment, it's okay to just give them a call and say, "Hey, I just want to let you know, I'm still working on your case. I haven't heard anything from opposing counsel." Let them know that you're there. Next slide, please. And be aware of any implicit biases you have. Studies show that their unconscious biases are pervasive. And avoid being swayed by any non-relevant demographic information. Don't make assumptions about a person because they may have a disability or they may be a single mother. Keep those and check those at the door. Come in with an open mind. Slow down when you make your decision making. A lot of the times when tenants are in landlord court, landlord-tenant, they're rushed. They have to go. There's a lot of cases, so it's understandable. But when they're talking to you, take your time with them. Make sure they understand what is going on. And understand how these issues such as mental health may interact with your client, or how the challenges such as mental health can affect your interactions with your client. Does your client have a caseworker that you may be able to talk to? Is there someone in the family that your client can trust you with to have that conversation? But remember, you have to get your client's consent if you are going to talk to one of their social workers or someone in the family. Another example, I have another client who does suffer from mental health, and she does take medications for it. But there are times that when she would call me, I noticed that she's just not there, that she's having a bad day. So because I built that relationship with her and I've gotten to know her, I'm able to know, okay, today's not a good time to call her. I will say, I'll call you back tomorrow and try again. Don't give up on that client. Have patience for them. Create a plan, staying in touch with your client. This is very, very important. Not all clients have cell phones. They do, and I've learned that not many have email access or internet. So when you meet with your client, ask them, what is the best way for me to call you, write to you, or email you? What works for you? And what can I do to make it easier for the client? I've also noticed that I would get a referral and at intake, and I would call the client back and I would get no answer and no answer. I have noticed that 9 out of 10 times writing a letter to the client, telling them that you're trying to contact them to please call you, has really helped. So letter writing still happens, still exists, and is still effective. But definitely try to take that into consideration when working with your clients, if there's a certain time that's best for them to call you, or if they need to call you. There's also clients that won't pick up the phone if they don't recognize the phone number. So in your letter, you could tell them that you will try to call them at this time from this number. If clients miss appointments, and understand that they have other things going on, or it may be something because they don't have the money to get to the appointment, or they don't have the time, they don't have the money to get to court. So we do have to make sure that we keep open communication with the client so they are able to let you know what is going on. And again, this all starts with trust and building the relationship. I cannot stress how important that is to, when you meet a client, go in with an open mind. Take them as they are, where they are right now, because this is a very sensitive but extremely, extremely important time for the client. Next slide. And we'll talk a bit about the special client populations. A lot of the information is also found in your resource binder, tabs E1 through E5. Definition of disability is a person with a disability of an individual who has a physical or mental disability that substantially limits one or more major life activity, has a record of such disability, or is regarded as having such a disability even if the person does not. For example, somebody uses a walker or a wheelchair and they need more time to recertify because they cannot get to the housing authority in order to drop off documents. The fact that they have a walker or a wheelchair should be enough. Now, DC Housing Authority is horrible for this because they do expect that a doctor to write a note saying what is the disability, and then the doctor must also state that the disability is reasonably related to the reasonable accommodation that you are asking for. If a client receives Social Security income or Social Security disability, that should be, typically is enough to show the disability. Next slide. There are the 4 laws for anti-discrimination. DC Human Rights Act prohibits discrimination against and requires landlords to provide reasonable accommodation for individuals with disability. The Federal Fair Housing Act, that you'll be also hear it as the Fair Housing Laws. Section 504 of the Rehabilitation Act of 1973. This applies to all public housing owned by the DCHA and to HUD site-based subsidized housing. However, it does not apply to voucher landlords. Any housing provider that receives federal funds is obligated to accommodate the tenants. You also have the American with Disabilities Act, and this applies to public housing owned by DCHA and applies to how the DCHA administers all its programs. Next slide. The types of discrimination, there's overt discrimination and unequal treatment. You have individuals with disabilities, a landlord's denial of a reasonable accommodation in rules, policy, or practices or services if necessary to use housing. If the landlord denies one of these, that is a type of discrimination. Reasonable modification to a rental unit or common areas at a tenant's expense if necessary to use the housing. If the Rehab Act does not apply, meaning that it is not federally funded and the landlord is not required to make the modification, then the landlord, a landlord that's not receiving government funds should allow a tenant to pay for a reasonable modification, such as a ramp. If they need a wheelchair ramp in the house, the landlord should allow the tenant to pay that if they are not covered by a subsidy or receive federal payments. Does the landlord's intent matter? Usually not. It's not that they intend to discriminate, but they do. That should be enough. Next slide. Reasonable accommodations for individuals with disabilities. We at Legal Counsel for the Elderly do get this a lot due to the fact that our clients are elder and do have many disabilities, whether it's physical or mental health. With any client that has disability, you have the right to ask for changes in rules and policies because of the fair housing laws. Examples of some of the reasonable accommodations would be time to engage in services for a tenant who hoards. So I've had a tenant that has hoarding issues or housekeeping issues. We have asked for reasonable accommodation in order to get in a social worker to come in to assist with that, or volunteers, or create some type of plan for them to cure any violations such as hoarding. The DSM-5 states that hoarding is a disability, so that covers. Also, another example would be a waiver of a no pet rule to allow for therapy or support animals, a transfer to an apartment if something in that apartment is affecting the client due to their disability, or additional time to cure any lease violation, even after the tenant has been brought to court. So just because a tenant is being sued for, let's say, hoarding, they still have time, and the landlord must respond to your reasonable accommodation request. It does not say they have to approve it, but they must respond to it if they disapprove. Another example, a reasonable accommodation I just did recently, a client was getting notices from the landlord that he was violating the guest policy because he had an overnight aide. So we filed a reasonable accommodation request to modify the guest policy in order to allow him to have an aide during the night hours. And that was approved after we received documentation from the doctor that supported his need for an aide in the evening hours. And next slide. Common threats to housing for elderly tenants. Limited income due to lack of employment. So if a tenant doesn't receive a subsidy, and let's say they lived in a home for many years and they're renting and they have and they are not subject to rent control. If a landlord then rents that house, the tenant may be able to stay in that home, but the new owner may have a right to raise the rent. So this is very difficult, especially clients that, elderly, that only have their Social Security as their income. It's hard to defend these cases if they cannot pay rent. So we would assist them in time to relocate, assist them with searching for housing or other alternatives. Another threat to the housing would be cognitive impairment and or mobility limitations that inhibits the payment of rent and income recertification. As an example I used before, if someone cannot recertify on time due to a disability, then you would ask for a reasonable accommodation. Or if they cannot pay their rent to the rental office because they're in a wheelchair and that's difficult for them, you would ask if they can do something online or mail in the rent. Those are reasonable accommodations that can be made. Breach of lease for housekeeping or hoarding issues, support animals. Those are all other threats that clients are brought to court if they are hoarding or if they have an animal, but these are defenses that you can use in order to help the clients keep their home. Lack of supportive services to remain housed and independently safe. If you notice that your client is an elder especially, and they don't have a social worker or they need more services, reach out to your mentor and ask them, what services are there available? In your binder, I believe it's tab E3, there is a list of supportive services in DC. There is a lot of help out there. A lot of them go by which ward they're in. There's community social workers that work with clients that can then help you represent your client in court. So definitely reach out, and it's okay to ask your mentors for help. Dealing clients with disabilities, with mental health issues is a challenge, especially if you've not done this before. And that's what the mentors are here for. Okay, next slide. Protections for survivors of domestic violence. Under DC law, tenants are protected from eviction if an intrafamily offense or action relating to an intrafamily offense is a basis for alleged lease violation or an unlawful activity. Where this comes into play is, let's say there was a domestic violence incident in the unit, and as a result of the incident, an individual was arrested. So now you have the landlord come in saying, well, we want to evict this person because of criminal activity, because of an arrest. Because of the DC law and the VAWA law, a person cannot be evicted if their reason is because of a domestic violence incident. They are protected from that. And some of the options that they may have, the landlord, is to either terminate the housing for the offender, or they can bifurcate the tenancy. If the two people live together, then they can bifurcate where the one person will then have a separate home and be protected from the assault. Other protections in subsidized housing would be the right to remove the perpetrator and the right to transfer if the person is feeling unsafe. And again, that would be in your binder. I believe it's tab E1. And last slide is protections for limited to no English proficiency tenants. The DC law requires that a notice to cure or to vacate must be in Spanish and English. If your client speaks Spanish, and even though your landlord may not know that your client speaks Spanish, if they did not receive a notice to vacate in Spanish, then that could be a defense. However, if your client does not speak Spanish, that is not a defense for them. DC Language Access Act of 2004 requires that DCHA, DCRA, and other government agencies provide interpretation services. And also DC Human Rights Act prohibits discrimination on national origin discrimination. Because the DC Superior Court is funded by the federal government, then they are required to supply and have interpretation and translation capabilities. Once you receive the court's summons, if your client does not speak English or needs an interpreter or translation in court, you can request that before the hearing online. It's very simple to do. You let them know what language you need the interpreter for, and they will have an interpreter available in court. And they are also having interpreters available for any web hearings that are currently taking place. I know that was fairly fast. I'm trying to get you guys out of here, not too late. Again, we really appreciate you doing this work. It is so important for the clients to keep their home, and we really do. Again, thank you for your time. If you have any questions, please feel free to put it down in the chat.
Thank you, everybody, for coming. Thank you to Selena and Melanie and Beth for your presentations. Feel free to contact us with any questions, and please talk to your pro bono folks if you're interested in cases, and we will try to get cases to you. And there are 2 more sessions of this the next 2 Thursdays that we hope you can attend, and we promise to be more on top of ending on time the next 2 sessions. So again, feel free to contact any of us with questions, and looking forward to seeing you guys next Thursday.